Dispute is inevitable, but damage is optional. From boardrooms to borders, we unpack how negotiation, mediation, arbitration, and conciliation are defining how the world revolves and resolves conflict. This is the Alternative Dispute Resolution Center, giving you Resolution Reimagined. Welcome. My name is Nanza, the Executive Director at the ADR Center. And today I am excited to be here, not just by myself, but with another very passionate guest host, because she is part of the ADR Center, and you get to meet the other half, the right brain of the ADR Center. Before I introduce her, I would like to give you a minute to look around. As you can see, we are in a very different setting. Take a moment and see, because we are at the Tableside Tales restaurant. And what a day and what a way to have a tableside conversation in a place that embodies just that and the spirit of ADR. Welcome with me, my friend, my business partner, my sister, Damali. We are going to talk about ADR from the heart. As founders of the ADR Center, we do share a vision and a passion. But before we get into that, I will ask Damali to introduce herself, not just professionally, but also her real heart behind her transition from one career and digging 10 toes into this ADR space. Welcome, Damali.
Thank you, Nanza. My name is Daman Kathaire. I'm an advocate. I practice at Utajira and Company Advocates in Barara, Western Region. I'm a director at ADR Center, where I work with Nanza. We are passionate about ADR. Nanza, you asked me why the passion, or to share my experience as an advocate. For the years I've been as an advocate in litigation, trying to find solutions for clients. And by the way, on the other side, I'm also a businesswoman. So in one way or the other, I also face the same challenges where you have conflicts and you want them resolved, and then you don't get what you expect at the right time because of the processes of litigation, because of, in Uganda we are talking about case backlog, which is really a serious problem. And what the community wants is a solution which is faster and quicker. You cannot find that one from any other method of dispute resolution apart from ADR. So being affected as a business person and also being passionate about having, solutions for my clients, I decided to venture into ADR, and I've seen it work. It is working. When people decide to embrace ADR, at the end they thank you because they really get what they want. So Nanza, that is the background why I had to transit from litigation, though I still do for those who still want to remain in courts. But most of the times we are trying to educate the public, we are trying to educate the business community, the investors, to understand how ADR is the best method of dispute resolution that they can embrace as business people, and it works for them because of the so many advantages. Because ADR, of course, it serves relationships. When you are in court, as litigation as it is adversarial, parties become, enemies. You're no longer talking, your relationship is strained, your businesses come to a standstill, and that's what not you want. What you want is that even when there is a misunderstanding, as parties you're still talking, your businesses are going on, and you're also ready to engage in the same or different businesses with the same party next time. This can only be found in alternative dispute resolution, and this is why we are putting all our efforts to make sure that the public gets to know about these modes of dispute resolution, to make sure that the public is ready to transit from the formal court litigation system to alternative dispute resolution, which is going to save them time, money, and relationship. So NANZA, that is my background, and the reason why I had to dig deep into ADR. Tell me about yourself. What is that story behind, and why are you interested in ADR?
Thank you very much, Damali. Indeed, this is a tableside tale at the tableside restaurant, because we are going beyond the surface reasons for even starting this ADR center. Mine, to be very honest, was born out of a pain where I saw that disputes were hurting more than helping, but also resolving them was another challenge. In the understanding that the best dispute, honestly, in my view, is one that doesn't happen in the first place. So I've wondered if everybody knew ways to avoid disputes in the first place, no matter the complexity, from a land matter, a tenancy agreement, to the cross-border ones. We see geopolitical ones where we assume that dispute resolution is for when Iraq is fighting Ukraine, or Ukraine is fighting Russia. And then we forget that in our everyday decisions, we have options. And for those of you who are joining us for the first time, we have very many videos on our website, the ADR Center, explaining the dispute resolution strategy, so that you don't get lost as we discuss and you think that, oh, that is for people who are fighting world wars, or for those big companies that are fighting climate change disputes. We want to demystify, and we have a whole video on the myths around ADR. My story comes in when we want to help the business community, especially the SMEs, to avoid dispute in the first place. We have very many options, what we call option analysis at the center, a spectrum, the way you have a rainbow, where you transition from negotiations to mediation to conciliation to expert evaluation, all the way to arbitration before you go to dispute resolution, in what many people are confusing between arbitration and litigation. My true heart for businesses and individuals out there is to explore dispute avoidance. We have mechanisms, like I have said over and over in this forum, where we handhold people, and I have seen them work. The real pain for me is when you realize that a relationship has not only been severed, but a dispute has not been resolved just because a judge has said, turn left, turn right. I've also seen and heard where a dispute is beyond money. Like the previous videos where I talked about mediation, and we realize that when you go to the heart of a dispute, sometimes it's dignity, sometimes it is ego, sometimes it's just a power struggle. That when you are skilled and empowered, one, you the professional helping the people, but also if the parties understand what we call the anatomy of disputes, then you go beyond settlement, beyond resolving, then you restore, what we call transformative dispute resolution. Again, dispute is inevitable, but damage is something that can be avoided, whether in business, personal, corporate, even country to country. So that is my heart for ADR. We have seen the professionals getting skilled. We take time, we study, we get skilled. Then we realize that the users are still somewhere stuck between, first of all, the terminology, then the myths. One of the myths we burst in our previous conversations was about ADR being only for lawyers. And then people have this thing of, oh, I don't trust lawyers. So we are going to handhold companies, corporations, individuals to understand, to craft dispute resolution strategies at every stage. Before you enter a contract, let's think with you and let's think through, what if a dispute arose based on the parties, what would be the best course. And as we've also been learning over the time, that there is no one size fits all. We have combos, just like a tableside restaurant has combos. You can have half and half mediation, half arbitration, but you still need to be guided by a professional. And this is very exciting because it's going to help us understand the benefits, but also understand the limitations, because we are not going to sell to you a beautiful Cinderella story. So I'm going to ask Damali to share her experience in light of what is possible, an honest conversation. What can mediation, arbitration do, and what can it not do, so that we start from a realistic leveled ground for people out there who are picking interests.
Thank you, Nanza. In your conversation, you talked about where people, confuse different things to be the same. I want to start from there, not even a month back. So I was trying to educate this client that instead of rushing with the court processes, we can be patient and try to engage the other party to be able to come and we talk about this. I intended them to have at least a mediation. My client easily understood what I was saying, and she bought
You
the
were
idea.
counsel.
Yeah.
Was that what we call the complainant or the petitioner? Like, we have to break it down.
My client is the respondent.
The respondent.
In the other case, yeah.
Okay.
She has been sued. So when I explained to her that there is an option of reaching out to the other party, then we talk about these issues. For her, she was, she quickly understood. So from there, for her, she thought that I have the powers, or court have the powers, to force the other party also to come to the same understanding and make sure that they do the mediation. But I've been trying to tell her, no, that's not how things work. For you, we are lucky. You are able to understand it from day one and say, it's okay, we can mediate. So we need to talk to this person also so that he can also be able to understand and come to the mediation.
The principle of consensus. They had to both understand.
Yeah, they have both to understand that it's, two parties have agreed to come together and resolve their conflict with the help of the third party. That is the mediation. So simply put, in mediation, both parties must have agreed to get a neutral third party who is going not to give a judgment or to force any agreement upon the parties, but to facilitate the talking so the parties can be able to come up with an agreed position which resolves their dispute. This can be very fast as long as the parties are able to agree and they come to terms and we are ready and say that we are ready to do the mediation. And this is different from when you go to arbitration. For arbitration, it is a process whereby the two parties who are in a legal contractual relationship agree from the inception of their contractual relationship that when any disputes arise, or all the disputes that will arise from that contractual obligation will be resolved through arbitration. So once that one is in place, and when these conflicts arise, you will not need to do a lot of sweet talking the other side to come to arbitration.
Because they have agreed.
Because you agreed from the beginning, which is not the same case with mediation. Yes. So for arbitration, you already have arbitration clause in your contract. So the affected party can start the arbitration process by according to how you have agreed, whether it is going to be ad hoc, whether it is going to be institutional, individual, something of that note. So for arbitration, the party must participate because there is an agreement to participate through that process of arbitration to resolve their conflict.
So basically what you're saying, mediation, there's a bit of want to, and you as the mediator in this case, or the dispute resolution person, you can encourage. But arbitration, because they chose it at the start, then they are obliged. It's like when you choose the path, it's like when you're driving on a one-way street, you can't turn back and say, now I'm not interested.
Yeah, you cannot turn back unless both of you at a particular point agree. Yeah. But without the agreement for the both of the parties, you're tied to your arbitration.
Which also means that you can't just waltz in and out. The minute you commit to it, somehow you're already committing to seeing the process through, which is a good thing.
Yeah, you can't. You can't just say, I'll go for arbitration, then after I'll go to court. Because arbitration gives a final and binding decision, which is known as an award, which is binding to both the parties and which is not appealable. There are only exception circumstances under which you can apply to court to have the arbitral award set aside. But those provisions are under the Act. You cannot come with any reason to have the award set aside. There must be those very reasons stipulated in the Act.
So, and the Act you're talking about applies whether it is a domestic dispute like the Arbitration and Conciliation Act of Uganda, but also if it is an international dispute, because somebody in the business community there is sitting and thinking, oh, okay, that's a Ugandan thing. If my business is Kenyan or Rwandese or Brazilian, then I can play by my own rules.
No. Our Arbitration and Conciliation Act handles both domestic and international arbitration. So when we talk of domestic, which means both parties are Ugandan. And when we talk of international, which means it can be a Ugandan dealing with a Kenyan, can be a Ugandan dealing with a Tanzanian, or from any other country. So those contracts those awards can be enforced here in Uganda under our Arbitration and Conciliation Act.
That reminds me of a dispute. Of course, we don't name parties here, where it starts with arbitration, but based on that leeway where they think that when it's time to enforcement of an award for our dear viewers and listeners is after the arbitrator has written there what would be the equivalent of a judgment in court. You can take it to court and it is enforced as though it was a court decision. The law allows that. But here is the trick. When a party usually is dissatisfied, they find any reason to come to court and say, we do not agree. But first of all, the courts are bound by law and statutes, especially in the Ugandan side, that if a decision has been made, except for the circumstances that Damali has highlighted, an arbitral award cannot simply be put aside because of sentiments. And more than ever before, even the courts are realizing that it serves their interests when the alternative route has a finality end so that people can go to it confidently, especially in the business community. So the case I'm talking about, they went for arbitration, and of course the other party wasn't happy, and they appealed to set aside. And for some reason, they went to High Court, they went to Court of Appeal. Because you can appeal a set aside at High Court level, for whatever reason, on points of law, not facts, because we are not disputing that the person who was conducting, that is the arbitral tribunal or the arbitrator, was not empowered. So you can appeal on points of law. At first incidence, the first time, the High Court can listen. So they went to High Court, tried to set it aside, then they went to the next court, and then went to the third court. But again, to give you comfort as business people, as individuals, that arbitration does not work in isolation of the law. Even at the highest court, they were sent back to arbitration. One, they were reminded that when you choose arbitration, you have chosen to have your justice through private means. But also, two, the laws work together in such that the only time a court can look at your appeal is if the High Court, for example, in commercial dispute, was the original court. Meaning that if you did not start with the court process, there are very few grounds where a court can allow you to now come back. Like you can't have your cake and eat it. But that's also not the hard part. As trained practitioners and strategists, we know that if you start the dispute resolution side, which is ADR, sometimes the contract gives you a leeway where we have either made up, you can start with mediation, or in the side of construction where they say you can adjudicate. We have a lot of information on these methods of dispute resolution. Please look at our previous videos. That by the time you go to court, there is a risk, a real risk that things like damages can be reassessed over time to factor in the time value of money, where you are running away from a claim of, say, 30 million, 40 million that an arbitration has given you. By the time you go and you take another 12 months, 18 months in the court system, of course, from a business perspective, 30 million is not 30 million in 2 years.
No, it's not.
So what we are saying here between me and Damali, besides coercing you to save relationships, to have confidentiality, we are telling you that it sometimes makes business sense to run with a decision today than wait for one that will take longer in terms of time value of money. But again, back to you, Damali, I heard your heart on what the challenges are, and then it reminded me of times when really, honestly, this ADR may not work. You've talked about it where one party is not sold in. As a business person on the project side, is the times when the goal of the dispute is to expose. We talked about it in mediation, but a business decision that comes to mind. There are some organizations, if you go like to the private and third sector, NGO sector, sometimes their goal is not so much about preserving the relationship, but they want to expose maybe somebody who is destroying the environment. So do you think of scenarios in your practice where you say, if you are strategizing for a client, where I would say your best route is litigation, because these systems work hand in hand? Fraud, what else? Things along the line where alternative dispute resolution may not be the best.
Oh, yes. The law on alternative dispute resolution in Uganda is very clear. There are cases where you cannot go for ADR. As Nanza has said, for example, for fraud, for criminal cases, for family matters, you cannot go for ADR. The parties cannot sit, for example, and agree to divorce. That is contrary to public policy. The policy of Ugandan law is to protect families, to make sure that families remain together. So if they allow parties to sit and say, today we have decided to divorce, that is contrary to public policy of protecting families in Uganda. So you cannot go for ADR for those kind of disputes. They must go through court processes where court will decide basing on the customs and the laws of Uganda that govern such conflicts. Also for criminal cases, criminal crimes are committed against the state in Uganda.
Yes.
Yeah, so they are not individual. Though Nanza, you have committed a crime against me, the government takes it up. Me, I just become a witness of the state. So me, in my capacity, I cannot sit with you, Nanza, and say that we have settled it. The state must be involved, and the state is saying that no, you cannot arbitrate, you cannot, mediate, in these cases where the government must come in to make sure that they are determined according to the laws of Uganda.
So even where there are cases, it still borders around fraud and criminal. If you have domestic violence, child abuse, then you cannot run to ADR because the very tenets like confidentiality, which alternative dispute resolution, the one it embodies where your things will not go public. If you are a company that is using child labor, if you are abusing the environment, then ADR is not your hiding place. It's not your safe place.
It is not.
So because we are speaking to both individuals and corporations, we do not want to sell a false dream. There are limitations and but on the other side again, if you are, for example, in the third sector, which is the NGO sector, and you want to create awareness around, say, an ESG issue, land abuse or environmental degradation, I think the court system, because it is public, and then it allows, there is no real limitation on information sharing. There are precedents because some of the advantages we know that your outcome is also private, so nobody is going to know your data linen as a company or as two individuals. Yet on the other side, if the goal is to create awareness about an ill, a community ill, then we encourage you to go for litigation so that the public knowledge about the issue can be disseminated. So you see, as companies, as individuals, it is important that you have a dispute resolution strategy. So we think that if you set out to enter into any contractual obligation, I personally think the best time again to stop a dispute is to avoid it from happening.
Yes.
And that now brings us to our next discussion, our next tale. When do you think is the best time to start this dispute resolution?
You know, in the first place, Nanza, the best dispute is the one that
never
happens. You know, that would
we
be
can
the
say
starting
that
point.
over and over again.
That would be the starting point. If people can really work hard from the inception of any kind of relationship to put measures in place on how to avoid these disputes, it would be the best thing to do. So, of course, it is well known that when people get into relationships at different levels, conflicts are bound to happen. But if they are bound to happen, something that you know that is going to happen, then you can plan on how can I avoid it. So this brings us to the topic of the dispute avoidance mechanism. How can it be done? What practices can organizations, businesses, individuals, put in place to make sure that they avoid conflicts of certain nature, to make sure that their businesses, their relationships, their strategies are not jeopardized because of these disputes? Now you're going to take us through some of these practices.
Thank you, Damali. And this is at the core of our practice and something that is very dear to me. First of all, before we decide what we are going to do about the dispute to avoid it, there are three places where we can avoid. We can avoid disputes at the start.
Oh, yes.
We can avoid disputes at the drafting. We can avoid disputes post when the ink has dried. And that is where a skilled professional comes in. My take on dispute avoidance is to, the way we say, face your fears. If you feel already from the beginning, as you do early negotiations happen even before you sign the paper. Let us avoid disputes by having a negotiation strategy. If you don't feel competent as an individual, find a professional. Let them hear your thoughts. In negotiation, it's about interest versus positions. Sometimes the things you see on paper are very different from what the person really needs. So you start from the negotiation stage where you have a negotiation strategy to guard your interests as opposed to positions. We do have a lot of information on that again on our website, and we have skilled people to help you negotiate at the ADR Center. But should you find yourself maybe listening to this video and we're like, oh my God, we just signed the contract yesterday. It's not too late. There is a way to wiggle out on what we call pathological dispute resolution clauses. And this is where ADR, all the things we are talking about, they are not just good on paper, but they become business strategy. When you avoid disputes, whether at the start or as you have discovered that you had a pathological clause. Pathological means maybe you have written in your contract something like, in case we disagree, we shall do amicable settlement or litigation. And sometimes when you're drafting these things, you're shaking hands over coffee like this, everybody's happy. Then you put something like amicable settlement stroke litigation. What does that mean? You need to be able to craft a dispute resolution clause, strategically thinking about amicable settlement. What does it mean? How long shall we try this amicable settlement? Is it a month? Is it a week? Is it 10 years? Because we also know, especially with my business community, that sometimes, like your client who refused to come, the claimant, people know that there is a dispute, but they are using every trick in the book to prolong.
Yes.
Imagine a land wrangle where someone knows that they illegally got the land, but they are buying time as they are continuing to develop the what? The land. So a dispute resolution strategy, like at that point, helps you to craft a clause. So we have talked about before you sign, but if it's too late and you already signed that tenancy agreement, that business deal, that importation, that deal with government, you can correct the clause. Because again, ADR works on the principle of party autonomy. At any time, you choose the rules.
Yes.
Unlike where in court you say within 7 days, within 10 days, party autonomy simply means you choose the rules, you choose the playground, you choose the referee. So pre-contract, during the contract, and post-contract. You asked about when the best time is to avoid disputes. I say at any time. As long as you have the right professionals to give you the options and the pathways, which is really our mantra, pathways and the partnership to guide you through. So dispute avoidance is not just another wish list, but it's a tool to manage risk, contractual risk specifically, but also to navigate the long-term business sustainability. Just not relationships, you're safeguarding your money, but also when it comes to projects. The objectives of the project is usually there's a time factor.
Yeah.
Even when you get a good resolution somewhere in between the project, you've lost time. And time is money. So when we advocate for ADR from the project side, from the business side, the avoidance becomes a tool, a proactive tool that you have in your bag to even avoid the risk, but also to give you sustainable business outcomes.
Nance, I would want to add something there. We've talked about the party autonomy in these ADR processes. So you talked about the clauses which cannot be enforced, and we say that there is party autonomy. Then, because of the principle of flexibility, these modes of dispute resolution, they are very flexible. So even when you have a clause which you think that at a particular point it is not going to work for you as parties, you have a right to change it. You can sit again and negotiate, as she's saying, and say it was saying that we shall do A, B, C, D. But according to the circumstances now, we choose to do A, B, C, D. You can put that one in writing, changing what was, seeming to be difficult for you to be able to move on according to the prevailing circumstances, according to different reasons, and be able to vary your own contract, even your own arbitration clause. For example, you would have said that we shall go for arbitration, but along the way you realize that you can end in mediation, and you end it there. So that flexibility also gives the parties the option of taking control of every process compared to the other side in litigation, whereby you are controlled by the processes and you don't have any option apart from following them, how frustrating they are. No matter what, you have no option. So we would encourage the business community, the investors, individuals, please think more about alternative dispute resolution. It has all the possible ways and options for you to be able to handle your conflicts. Let it be at the beginning. How can you plan to avoid those conflicts? And when they have crystallized, the best options to choose from, how you can have them resolved. Nanza, when you look at the environment, the practices, and what is happening around the litigation, arbitration, ADR, and the trends in the business community, the trends in the society, where do you see the future of the dispute resolution? Are people tending to keep going to court for litigation? Are they tending to move towards the alternative dispute resolution, looking at what the government is saying, looking at what the judiciary is saying, and the big stakeholders in general in the business community and government? Where do you see all this ending?
I think it is a foregone conclusion. First of all, even the judiciary has accepted. We have the facts nationally as far as the case backlogs, the overwhelm on the judicial system. We do have even the practice where we have learned that 90% of disputes are resolved outside court willingly. We have seen government reform where even current recommendations and encouragement is for parties to try. For practical reasons, for relationship, and for transformation, we are going back to appreciating that dispute resolution, alternative dispute resolution, is not an alternative. It is actually the most appropriate. We have scientific data to prove it. We have the judiciary saying, we are tired, we need help. We have the business community saying, we want faster.
We want resolution,
not settlement. But most importantly, what we see shifting is the people's view of what transformative dispute resolution is. Honestly, even when you walk away with a win in court, there is a sense of loss. You might get the money in the bank, but there's something that a part of you is chipped away. Even the users are tired of adversarial resolutions. Are there challenges with ADR? Yes. So I do see an uptake. You asked about predictability, an uptake, starting from a top-down approach, government reforms, policy recommendations. The country has an ADR policy where they're encouraging. When we come to the industry specific, we do see even PPDA where we have contracts. They have added at least layers of alternative dispute resolution before you go to court. We do now have PPDA where you have adjudication as a first step in the built environment if you have construction or infrastructure. We do have the judiciary leadership encouraging state annexed mediations with all its challenges, but they want to give people a chance to attempt at that. But we also see a surge in awareness and skilling of professionals, where even lawyers like you are adding an extra layer of qualification to support. But most importantly is the wide acceptance now from the users, where initiatives like this, people get empowered to understand. I'm not a prophet, but I want to think that anybody watching this video, before they sign their next contract, will think about what their dispute resolution clause will be and how it will best serve us. But also, for those who are dealing in high value, high complex, if we take this to maybe a global stage, even the financing, we do have third-party financing. It is new, just like AI, but there might be opportunities for people to get funding to resolve, the companies and the big ones. Speaking of AI, we are also moving towards online, where we can do dispute resolution.
You're talking about third-party financing in the conflict resolution? In Uganda, it's not yet.
It's not yet. That's why I say
legal.
That's what you said about AI.
You're talking about. Last time we were in the meeting, the Gumzo training you attended, and people raised it, and the Minister for Justice was present. Those are some of the recommendations that they took up. They're going to look at it. And make sure.
Of course, it needs to be regulated because sometimes, the conflict where someone is funding, then the outcome is a bit skewed. But the way, Damali, we saw AI, when a movement starts, you just have to find a way to regulate it. So third-party funding is so far away, but it is coming.
It is coming.
So the other one is facilitated online, where you don't need to go to court and meet the people. You can use digitalized tools so that if they get faster resolution. The other one I can think of is shortened processes in case of emergency resolution. The one that comes to mind is, I don't know if we have any football fans here. You know that the CAF returned the trophy from Senegal to Morocco, and it took 2 months. So that they were, the jargon that has been going around, the football laws and the Africa Cup of Nations. But you can imagine if within the sports arbitration or the sports rules they had that in case of controversy, we have an emergency panel that sits, and within 40 hours, they pronounce a decision. So we are looking at emergency panels that give you a quick and shortened decision, but of course they have to be trained. Then we are also looking at climate disputes, where we used to have communities being stuck with bad environmental, social, and governance decisions. It's no longer optional because they're now compliance related for funders. We will see that people will be interested in finding solutions, legal solutions, not a wish list where someone destroys the environment and then they come and build like a hospital to placate the community while they are making people sick with their pollution. So we have legal direction and dispute resolution in new areas like AI, in climate dispute, ESG issues. And for the larger community, I sincerely believe that the professionals are ready. It is the users now that need to educate themselves, demystify their myths, and build confidence in the alternative dispute resolution systems. I'm excited for the future of restoration, because not just for businesses, but the human relationships. Like, the world has enough problems already.
I know.
The world has enough problems already. Like, so that's what I would think. That IT, the new forms of dispute resolution like ESG resolution, and then the uptake of combinations made up, the multi-tiered where you start from one, you give it a time frame when it falls, as opposed to default. And this is where maybe we make our clarion call. Our mantra is simple and well thought through. ADR Center creates pathways. We have discussed pathway after pathway, and we hope you find yourself in one of these. We are discussing partnerships, not to obliterate the litigation side, but to give you a dispute resolution strategy. So come to the ADR Center. Check us out at www.theadrcenter.org. We do have a part where you can connect with us and say hello. Then we come back to you and share how we can handhold you individually, corporately, or as a region on your ADR journey. Damali, any parting shots?
Yeah, thank you, Nanza, for that elaborate discussion and conversation. My last, words would be that public, business partners, families, please, it's high time we rethought the way how these conflicts should be resolved, and think about the outcomes, whereby we have talked about ADR, strengthening relationships, and giving us continuity for those of us who are in business deals to be able to do other businesses. So I would think, and I would encourage every person to consider ADR as the best dispute resolution mechanism, and also as they think about avoiding the disputes, since we have seen it is possible. Once you try earlier, you can avoid some of the obvious disputes that would have happened, that would have disturbed your contracts and relationships. So try to reach out to us to be able to teach you more about dispute avoidance mechanism, to be able to tell you more about this alternative dispute resolution methods, which can be able to, help you avoid more problems, and to be able to save your relationships and save your projects, and be able to see the reasons why you entered these contracts from the beginning. That is it, Nanza.
Thank you. So a fun fact. Our listeners, do you know that you can have your dispute resolution here at the Tableside Restaurant? Like, you don't need to go to sit on the hard benches in the courtroom. You don't need to go and wear a black suit. You can see Damali is wearing a beautiful blazer. There are no rules on dress code. We can shrink the time. You don't have to keep commuting. So just to give you a glimpse of what ADR can do, you can sit here with your opposing party there, and you leave the Tableside Restaurant with a resolution. How cool would that be? Thank you very much for tuning in, and we look forward to hearing from you at the ADR Center, where we create pathways and partnerships to transform dispute resolution. See you in the next one.